Today is March 16th, 2022. My name is Felix Shipkevich, and I'm joined today with my colleague, Krystina and Endara, to discuss a subject matter that is very dear and close to our heart and has been requested by many of our participants in the past few months. And the subject matter is understanding and responding to civil investigative demands, or as many of you know as CIDs. This is a very interesting subject matter that we've covered before during our in-person seminars on the West Coast. And in recent months, we've seen a significant increase in CIDs issued both on federal and state level. And as such, we thought it would be, again, appropriate to discuss the subject matter with our audience and look forward to hearing your thoughts and your suggestions on future webinars. For those of you who are returning, we thank you for your loyalty. And for those who are new, we hope you enjoy our educational webinar series. I'm going to turn it over to Krystina to introduce herself.
Hi, everyone. Thank you, Felix. For those of you who I have not had the pleasure of meeting yet, my name is Krystina, and I am a partner here at the firm. I lead the firm's Florida office, which opened last year, and I'm happy to report is already growing since having been opened. My background is primarily in complex commercial litigation. However, I've recently incorporated a lot of transactional and regulatory work into my practice, which, if you've met me, you know is definitely my passion. I'm really excited about this webinar because, as Felix mentioned, this is near and dear to our heart since we've been working on a very lengthy CID for a client for quite some time. So it's a topic that we have been dealing with a lot with internally in the past few months. I hope you guys find the webinar to be informative. And with that, I will turn it back to Felix to begin.
Thanks, Krystina. Just a little bit about myself. I've been in the as a fintech lawyer, transactional fintech lawyer for nearly 2 decades. I teach a couple of courses at Hofstra Law School in Long Island. And I was a founding member of Consumer Debt Relief Initiative, and I was a secretary and a board member for 2 years, so recently. Anyway, here's an agenda of the topics of our discussion. We're going to try to make this webinar, as always, educational and at the same time provide a lot of our own feedback and thoughts. As you know, when we typically do these webinars, we do not want to just give you all the legalese. We'd like to provide our audience with our direct experience and information that you hopefully will find valuable and following this webinar. So with that in mind, well, we're going to discuss what exactly is a CID. I mean, that's pretty simple to explain. I'll explain in about a minute. When can a CID be issued? We'll discuss investigative hearings. We'll discuss the government's ability to compel a CID and also its enforceability. We'll discuss a few suggested steps in how to deal with a CID. And we'll close out the webinar with consequences of failing to respond to a CID, case limitations on the scope of CIDs, and of course, the key takeaways for recipients of CIDs. Now, what is a civil investigative demand? And I want to emphasize those 3 words. It's a civil investigative demand. It's not a criminal investigative demand. It is essentially, in the layman's terms, it's pre-litigation subpoena. It's not something that is issued after litigation has been initiated or commenced. It is issued primarily and substantially for investigatory purposes. Many of those who are in the debt relief space know CIDs coming primarily substantially from agencies like the CFPB or the FTC. But actually, that same power is afforded to DOJ. And so I've had a number of clients on the banking side, money transmitter side, technology vendors that we represent receive CIDs from DOJ. Of course, receiving a CID by itself is not the most pleasant thing. If you're not an attorney, if you're a company executive and you receive a CID, which will have a letterhead from the state and says, we command you to, usually say something like, we command you to appear. It doesn't really mean that you are going to be appearing physically, but it's just a kind of the common verbiage, and produce the following documents. Well, yeah, it looks pretty serious. It could certainly make a lot of people very uncomfortable, queasy. And the ultimate question that I want to discuss with all of you is whether or not you need to hire an attorney. If the question is asked, should you hire an attorney? Yeah, I think you should. Do you have to hire an attorney? No, you don't. I can tell you that CIDs should be taken seriously, and you should consult with an attorney in order to see how to properly respond to it. Unless, of course, you had the pleasure of dealing with CIDs for an extensive period of time and you know exactly what to do. And in that case, probably you might not need an attorney, but certainly my recommendation is for you to speak to an attorney about what to do next and how to properly comply. CIDs are purely investigative tools. That's exactly what they are. It does not mean that CIDs will result in enforcement action. It does not mean. Over it's almost 2 decades of being a practicing attorney, I can't tell you how many times I've heard attorneys scare the living crap out of their clients, indicating that when you get a CID, they're very likely to be sued. About 6 months ago, we dealt with a CID where we inherited a case from another law firm where the attorney was indicating that the client needed to be hiring a criminal attorney, which seemed kind of absurd without any justification. And actually, the good news is that CID was closed. There was no enforcement action filed. So it's just an investigative tool for the government, yet not to be taken too lightly. Don't throw it in the garbage can. Don't shred it. Take it pretty seriously, because if you don't comply with it, you could potentially be held in contempt of court, and you could obviously also be sued for failing to comply. Okay, and so ultimately, you are required to respond to a CID. When can a CID be issued, right? So here you have on this slide, it's right there in federal law, 31 U.S.C. section 3733. The U.S. Attorney General or his designee is authorized to serve CID before commencing a civil proceeding when a reasonable belief exists that a recipient of the CID has custody and control of the document, right? And as I mentioned a few minutes ago, a CID can only be issued prior to the commencement of formal civil proceedings. It cannot be issued afterwards. Afterwards, it's actually called a subpoena. So it's a pretty major distinction. It looks like a subpoena, it smells like a subpoena, but it's not, right? It's pre-litigation. It's a tool for investigation and information gathering purposes only. Once litigation is commenced, the government must use traditional discovery methods to gather the information on the CID recipient. Okay. Now, some CIDs will require to also have what's called investigative hearings. Investigative hearings. Not all CIDs will have investigative hearing requests. And let me kind of break this down a little further. You may get a CID, you will respond to the CID, and you will never hear from this agency again. That's one way it could go. Another way it could go is you receive a CID, you produce documents, and then you could be sued. And I want to be very, very careful in saying that that happens in minority of times. It doesn't happen very often. Many companies get CIDs regularly. When I was a general counsel of a CFTC regulated swap dealer and foreign exchange brokerage, the CFTC doesn't call them CIDs. It has a different investigative tool. I'm not going to mention that here, but I mean, I used to get them once or twice a week, and it was so common practice. I really didn't even blink. I just gave it to one of my attorneys to handle. We review the documents, we produce them. But the third option is you produce the records. The respective agency reviews these records, and then they ultimately will ask you to appear for an investigative hearing. Now, investigative hearings, are just like depositions, right? They're generally conducted under oath. They're generally conducted under oath, and you should prepare for them, absolutely. And you absolutely should, if you could afford an attorney, obviously use an attorney to ensure that you're not waiving your rights or you're not discussing anything that you shouldn't be discussing. One thing to keep in mind is that the rules about investigative hearings could differ, or the process of objections to questions raised during the investigative hearings could vary from agency to agency. And for instance, when it comes to CFPB investigative hearings, you really don't have the luxury to object unless it's something like based on attorney-client privilege, which your attorney will instruct you not to answer. You really don't have the luxury, for instance, on a CFPB level to object in the same way you could, for instance, when you have an investigative hearing with the Federal Trade Commission, right? Just to kind of have you understand that merely because something is called an investigative hearing, you do have different standards of objection, right? And this is obviously more for the attorneys who are participating on this webinar. But just like, with CIDs being technically subpoenas, right? Pre-litigation subpoenas, investigative hearings, and depositions. There are ways, historically, I could tell you that there are ways you could potentially limit for these investigative hearings not to be on the record. That happens pretty rarely. Usually that could happen if the Division of Enforcement or the respective attorney from Division of Enforcement will agree to not conduct investigative hearing on the record. It will be more of an informal meeting, but typically you should assume that these are going to be an oral testimony that is on the record and could be used potentially against you. So you obviously should consult with an attorney in terms of what you will be saying and testifying to. Okay, so why is CID a powerful investigative tool, right? And by the way, a lot of these questions that we're posing here are the ones that are specifically asked by many of our clients. Well, it's pretty straightforward. It's an investigative tool because as part of it, the government gets to see your books and records, the books and records in your possession and control. If you claim that you don't have those records or you're no longer in possession or control, they will ask you to indicate why is it so, right? You have to provide an explanation. Clearly, if in any way you're lying, you could potentially be facing criminal violations, and you don't want to do that. But yeah, you will be producing documents, and each agency has their own way that they will produce. They're required to produce these documents. Recently, a firm was involved in a kind of an intellectual debate with the CFPB, for instance, where we produced a privilege lock in the most simplest way, not in furtherance how the CFPB wanted it, just because it would be very costly for a client, and this is a client that really couldn't afford to do it in the proper way. So we did the privilege lock to ensure that the attorney-client privilege documents are properly produced and preserved, the privilege is preserved. But the attorney that was handling it insisted it to be produced in exactly that same way. And, we had no choice but to tell a client that we have to produce those documents in the way the CFPB's specific counsel wanted it. Even though previously for years, we've produced these records and the CFPB was always cognizant of the fact that there are costs involved. But, with each case and each CID will vary from person to person. Most of the time, the attorneys on the other side will understand that the clients that we represent may not all be big companies and have unlimited deep pockets to pay for legal costs. So they will, have some sympathy and have some understanding, but they don't have to, right? They don't have to. So a CID can consist of requests for production of documents, which I just discussed, a demand for or deposition testimony, which were in investigative hearings. And also they can serve interrogatories, right? Requiring a written response. And they're very similar to the interrogatories that you get during a typical civil litigation process. There'll be a list of questions and you have to respond. or object based on whatever legal grounds that you potentially could have. And then also a combination of both. Now, if a CID is challenged in court, generally, right, the rule of thumb is that federal judges, you would obviously challenge, if you were to challenge the CID, you typically would go to federal court, and federal judges will defer to the judgment and the law enforcement expertise of the issuing agency. And you know, a question that clients always asked us is, well, isn't there some sort of bias because if a federal agency is serving us with a CID, then wouldn't be you know, biased for federal judge? Well, no, it's a federal issue and it's a federal agency, and no, the judge is supposed to be objective. However, what Krystina and I always tell our clients is that before issuing a CID, a federal agency, you know, undergoes a very bureaucratic process. Sorry about that. A very, very bureaucratic process, and it's not something that they don't just easily issue CIDs, and you know, it requires multiple levels of approvals, and therefore, you know, don't assume that just because you got a CID, it was done by an intern, and that now you're stuck dealing with this headache, you know, and you know, it is a very, very bureaucratic process. What can I say to compel from a recipient? Again, production of documents, interrogatories, and testimony. Okay. Now, there are two implications of CID. CIDs are not subject to court approval. That's correct, right? It's not an uncommon question for our clients to ask, Felix, Krystina, doesn't the court have to approve a CID? No, the answer is no. The CIDs do not require court approvals. It is something that federal agencies are able and have the ability to issue in furtherance of their own respective rules, okay? Can CID be judicially enforced? The agencies that seek, issuing agencies can seek the aid of federal judge in enforcing a CID, meaning that if you're gonna throw it down a garbage can, or put into paper airplane and throw it off your balcony and say, I don't really care, I could tell you it could be judicially enforced. You could potentially get into significant trouble, including seeking, potentially could be held contempt of court. I cannot stress enough that you should not ignore CIDs under any circumstances. And here's a case where a party, in this particular case, Harbor Portfolio Advisors, actually a number of companies in the mortgage space, in 2016 challenged the CFPB's authority to issue a CID. And you know, here you have Harbor Portfolio purchased a number of properties that have been resold as land contracts, and when they received the CID, they petitioned the court to set aside the CID on the grounds that the CFPB lacked authority over the company, since the contracts for real property deeds were not consumer products. And they alleged that the scope and the time frame of the CID was unduly burdensome. The CFPB denied their petition, and even afterwards, they still actually refused to comply with their CID request. But ultimately, the court issued what's called an order to show cause, and it required Harbor Portfolio to respond with why the CFPB's petition to inform the CIDs should not be granted. This response highlights the court's reluctance to challenge the authority of the federal agencies that issues the CID, right? Now, of course, here's another case where you have limitations on enforceability. There are very limited limitations. And it's also a 2016 case, U.S. versus Kernan Hospital, and this was in Virginia, the federal court of Virginia. And the CID basically must be limited to documents not already in government's possession, right? So if a government has certain documents that either they've obtained through other CIDs or through other litigation, or they're publicly available documents, it's unnecessary for them to impose that burden when they already have those documents in the possession. Of course, it's kind of difficult being on this side, representing clients, just to inquire, well, you might already have these documents, and we really don't know what they have, right? There's, when we communicate with the regulators, it's not that they'll say, oh, Felix, don't worry, we already have bait numbers 100 to 5,000 from a different case. No, they don't usually do that. We've had circumstances where they asked for certain documents, and we basically said, you know, we would still obviously produce them, but we could say they're publicly available, but just a quick Google search, or, you know. So the second is they have to be relevant to the government's investigation, right? They can't just be for whatever they want, right? It has to be specifically relevant to whatever they're investigating, right? I could tell you from experience, I have never had a CID be issued where it wasn't relevant. You know, I've had clients over the years who try to be very creative and say, well, it's not relevant. Well, trust me, it's such a bureaucratic process within these agencies to issue a CID that raise the relevancy argument is very difficult, very difficult. I have yet to see one in almost 2 decades, but I would love to, you know, if you have examples where you have seen it, I'd love to obviously be interested to see. I haven't seen. And the information sought to be not to be unduly burdensome. And again, there's case law out there that what it really means to be unduly burdensome. And again, you have to, when you're responding on behalf of a client that has very limited financial resources, and you could prove them by providing tax returns, providing financial statements, you know, you know, from experience, the CFPB, DOJ, and the FTC are very open to understanding these issues. Most of the time, they're actually will work with you. You know, to be completely honest with you, when it comes to CIDs, I personally find regulators to be a lot more flexible on some issues versus when it's already in litigation stage. And that's what I counsel our clients, that, you know, don't create that unnecessary, you know, I'm right and you're wrong type of attitude from the beginning. In fact, try to work with the regulators, respond to a CID and work with them. And a lot of times when you work with them, you probably will never hear back from them, or they'll close the file. Okay, so that's it for my part. I'm going to turn it over to Krystina, and she'll discuss the communications during the CID process.
Thank you, Felix. Like Felix mentioned, the issuing of a CID is a purely investigative process. So it happens before litigation commences. And basically, what a CID is an administrative subpoena. We can communicate either formally or informally with the issuing agency. So, for example, of an informal communication, a lot of times there's investigational hearings that are requested by the issuing agency, and in connection with that, we'll have informal communications, coordinating the hearings, going back and forth. When is your client available? When is, you know, let's say it's the CFPB, when's the bureau available? Then there's all sorts of formal communications as well. And those, when you think of formal, think of formal responses to their requests, formal responses to the CIDs. Maybe there's letters going back and forth regarding a meet and confer that occurred, and objections that are being made specifically to the requests that are being made in the CID. So let's say their scope as intended is listed on the CID, and the requests that are being made exceed that scope. Well, then you'll have formal communications regarding potentially any objections. So there's all sorts of different types of communications, and I would say in the CID process that it's really a mix of the two. You know, phone calls, sometimes we'll just have phone calls and discuss a formal response that's being made, and we'll explain certain things that will be in the response to give the issuing agency kind of a heads up of things that are going to be there. It just depends. But all the discussions between the issuing agency and the recipient of the CID should be limited to the scope of the CID. So a good attorney is not going to open you up to additional questions by an issuing agency by leaving the intended scope of the investigation when communicating with that agency. So we as practitioners know to limit the discussions to the scope and to not provide any additional information outside of that, because what it does is it just opens you up as our client to additional questions that may not have been ever asked or on the table had those discussions not occurred. And so that's one of the reasons we always recommend having an attorney, because your counsel should know, hey, this is outside of the scope. This isn't relevant. And because the communications may be sometimes so informal, it's easy to just go outside of the scope when you're having an informal conversation with someone. And so that's something that we're trained to do and that we always do. And the last piece here, it just says, like I was just mentioning, there's positive and potentially negative ramifications by communicating with that agency. So this is really more for those of you who will receive a CID who decide not to have counsel. When you're discussing it with them, there's risks of potentially implicating wrongdoing and of saying things maybe that aren't outside of the scope, but maybe in the scope, but giving information on these phone calls or on these different responses that is not required legally, but yet will open you up potentially to implications that you don't want to be opening up yourself to. So if using counsel, obviously counsel would guide you on how to conduct yourself during these discussions, especially if there's investigatory hearings. Any of these hearings, you obviously want to be counseled on what basically how to conduct yourself. Felix, you mind going to the next slide for me? Thank you. So responding to a CID suggested steps. What's the first thing you're going to do when you receive a CID? Well, you're going to review it, right? You're going to look at it. From just reviewing the CID, you'll be able to tell who's issuing it, right? What bureau are you dealing with? What agency are you dealing with? Is the CFPB is another agency, like Felix mentioned? There's all sorts of agencies who have been granted the power to issue a CID, right? What else are you looking for when you review it? You're also looking for, are you under investigation or are you just a witness? All this information should be on the face of the CID. And then when we're looking at it, we take it a step further to review for proper format. So one of the requirements that CIDs have is that the scope should be listed on the CID, right? They can't just start asking you for a bunch of documents and information without basically giving you a little bit of, it's almost like an excerpt, and it's the beginning of the CID, and it tells you what they're looking for in terms of, oh, this is, potential violations of XYZ statute. And so as practitioners, again, we know to look for that format and to make sure that the boxes are being checked when we receive a CID. Number 2 is consider using counsel. So if you're not using counsel, you obviously still want to comply with any deadlines set forth in the CID. Whether you need an attorney is obviously a personal decision, but one that nonetheless should always be considered, and heavily. Maybe you're only a witness to an investigation and you feel that in your particular circumstance, it's not necessary to have an attorney, but of course, because of the potential ramifications of not responding properly or to conducting yourself improperly, we always recommend that someone who has been issued a CID, whether as a witness or whether under investigation, retain counsel. Institute a legal hold. So you have to preserve any communications, electronic files, hard copies of documents that would be potentially relevant to the investigation. This is very similar to litigation. For those of you who are familiar with the litigation process, it's the same thing. You're basically put on notice of something that's occurring, and basically anything relating to that needs to be preserved, because failure to preserve those records and that information can be considered destruction. Again, very similar to litigation. Felix, do you mind going to the next slide? Thank you. Determining whether a meet and confirm is mandatory. I touched on this a little bit earlier. You may have an obligation or an opportunity to meet and confirm with the issuing agency. The purpose of a meet and confer is usually to afford the CID recipient opportunity to clarify the scope. Usually there's strict deadlines that apply to this. Again, this is why we always really say you should have an attorney, because these CIDs normally carry deadlines, right? And so you don't want to, what we call blowing a deadline. You don't want to blow a deadline, especially a meet and confer deadline, because you might be waiving objections, right? You may be waiving an objection to relevancy. There might be information that they're asking for that you may not have to provide if your objection is sound, but that if you failed to issue, fail to raise that objection, then they can basically just go forward issuing that request, and you're stuck responding to it. Number 5, collect and review documents, determine whether disclosure, oh, can you go back, Felix? Yep, thank you. So collect and review documents to determine whether disclosure is necessary, and determine whether documents are privileged. Again, I don't want to keep hammering this, but another reason why having an attorney is good, because we deal with the topic of privilege a lot, right? What's attorney-client privilege? What's a work product? What is privileged material that does not have to be disclosed? And when you're representing yourself, you may not know what these privileges are, and that you can actually withhold documents based on this privilege. If a document is in fact subject to disclosure, that is technically privileged, it does not need to be disclosed, but it does need to be preserved nonetheless. Next one, Felix, please. Thank you. So number 7, assess the grounds and strategies for challenging the CID scope. That goes back to kind of the meet and confer. There's, just because it's being requested doesn't mean you have to necessarily respond to it. We have all sorts of communications sometimes with an issuing agency. They can be informal or they can be formal, where we say this is unduly burdensome, or this is outside of the scope. Sometimes we get requests for thousands of documents, and we say, is this really necessary? Let's just have a discussion about it. And most of the time we have really good experiences dealing with agencies, and most of the time they're very reasonable. And they might just say, okay, after an informal telephone call, maybe a 5-minute phone call, they might agree to limit the scope. However, if it doesn't go as planned, and you do have an issue where you are not able to limit the scope, and you or your counsel feel very strongly that these information requests are being made improperly, then you can file a motion to limit or quash, right? So federal agencies, including the CFPB and FTC, allow a recipient of a CID to file a petition to limit or quash the CID, which means to get rid of it altogether, within a specified period of time after being served with the CID. So this means the recipient may request that the CID scope be narrowed, or that the CID be withdrawn altogether. Obviously, you have to have proper legal grounds in order for that to be a successful means. But this is always an avenue that should be considered if the recipient feels that the information sought is being improperly sought, or that it's outside of the scope of that CID. And then lastly, prepare your response to the CID. So CIDs, and Felix touched on this, if CIDs can be, it could just be, hey, we wanted to do an investigational hearing, or it can be, hey, these are just document requests. It can be a mix. It can be anything like that. But most of the time, we will always have some sort of document request. And so we'll provide written responses to that CID. We'll provide an actual typed up written response within the prescribed period of time that the agency is giving us. And basically, anything else that might go along with it, with the request, or if it's just maybe like it's interrogatories, still, that even though those are not documents that are being requested, those are answers that are being requested be answered, or questions, I'm sorry, that are being requested be answered. Again, those are documents and requests that we need to provide responses to, which we'll do, or which you will do if you're not being represented by counsel. You can go to the next one, Felix. Thank you. Failure to respond to a CID is very serious. So the process of that is you're found in contempt, potentially, and then after a finding of contempt, you can be criminally charged. So, even if you're submitting a deficient response to a CID, this can also lead to really bad circumstances that you don't want to be in. So a deficient response may allow the issuing agency to even investigate further and potentially commence an enforcement action in federal court, which will cause you to incur added costs and might even open you up to other damages in the future. So you definitely don't want to, not only do you not want to not respond, but you also want to make sure that your response is not deficient in any way, shape, or form. You get a request that you haven't objected to on relevancy, and then you don't really answer it. That's a deficient response, right? And that could open you up to an enforcement action. Most of the time, these agencies are very, very reasonable. But if you're being evasive and you're not answering the questions that are being asked of you, and the agency feels that these efforts are not getting them where they're trying to get in terms of their investigative purpose, then they can just move forward with an enforcement action. So that's also something to be mindful of. It's not only responding, but responding properly. And federal agencies can pursue a broad range of remedies, including monetary redress, restitution, equitable remedies, temporary injunctions, permanent injunctions, asset freezing. So there's a whole slew of ways that they can seek remedies. They can also refer potentially criminal violations to the Department of Justice or the U.S. Attorney General for further action. You go to the next one for me, Felix. Thanks. So case law limitations on the scope of CIDs. We're going to go into some case law that might be helpful in terms of understanding this whole process. So there's a recent case, a 2018 case out of the Southern District of New York. It's styled U.S. versus Anthem Inc. In this case, it's a very helpful case because it creates a 4-factor test to determine whether the scope of CID to compel deposition testimony of recipient is permissible. So if you're a practitioner, you kind of know how it works when you read these type of factors, but if you're not, if you're just here learning about this for the first time, you basically read through these. This is a conjunctive test, meaning all of these factors are taken into consideration instead of a disjunctive test when only one of the factors, for instance, are taken into consideration. And you'll read these together to determine whether the CID is permissible. So in this case, let's read through these to give you an example of what the court found to be permissible. So an investigation that occurs following the issuance of a CID must be conducted for a legitimate purpose. This goes back to things that are objectionable on a CID. It must be for a legitimate purpose, right? Does that agency have the right to be investigating this conduct? Is it within the scope of their rights to do that? The inquiry is relevant to the legitimate purpose. So, right, so the requests that are being made must be tied to the purpose of that investigation, like we talked about before, or the relevancy objections, etc. The information sought is not already in the government's possession. That one's self-explanatory. And requisite administrative steps were followed in issuing the CID. And that one's also pretty much self-explanatory. So again, a conjunctive test to decipher whether a CID to compel deposition testimony is permissible. And all of these must be true in order for it to be permissible. That's a good example of some case law that's helpful. So issuing of a CID after litigation has commenced. This is another good case that just provides helpful information with regards to the CID process. So in this case, the US government alleged that the owner of Lexington Foot and Ankle Center, Dr. Allen, misrepresented the provision of podiatry services in claims he submitted to Medicare Part B and the Federal Employee Health Benefits Program in order to qualify for reimbursement. He also was charged with falsifying patient records, substantiated fabricated claims, and after the litigation commenced, the DOJ issued 5 CIDs, which, keep in mind, you can receive multiple CIDs from the same agency on Dr. Allen and Lexington Foot and Ankle Center. So they challenged the issuance of the CIDs on the grounds that federal statutory law required that the CIDs be issued only before litigation has commenced. And in this case, this is very interesting. Kentucky's Eastern District Court ruled in favor of the recipients, finding that the CIDs were invalid for failure to be issued prior to the commencement of litigation. So this goes back to that 4-factor test that we were just talking about out of New York, that talked about that administrative guidelines must be complied with by the agency when issuing a CID. And this is something that your counsel will look at to make sure that a CID is proper before just responding to it. So, you know, in this case, luckily, this was raised, right, by the recipients, and it was a successful objection and litigation ultimately to basically say these are improper. But had these recipients not known that they had the right to bring this up and the right to defend themselves against these CIDs based on the fact that they were issued without proper administrative following of guidelines, then they would have just responded to the CID and basically opened themselves up to questions and an investigation when they didn't have to. So that's a prime example of what we're talking about here. Next one, Felix. So what are the key takeaways? Basically, consider consulting an attorney. We already talked about this. Ensure compliance with the CID. This one's huge. So, you know, there are all sorts of requirements that you need to comply with on a CID. There's always normally deadlines, right, for the information that they're providing. If there's hearings, they'll set dates. They'll usually work with you on those, but always keep in mind when you're reading a CID, when you're receiving some sort of from any agency, any correspondence from any agency, keep in mind any dates that are listed there. It's always good practice. There's also format requirements that we see on almost every single CID that we receive. So when documents are being submitted, sometimes they don't want it in PDF, right? They want it in a different type of document. And if you're failing to provide those documents in that specific format, well, then you're out of compliance. Most of these have also specific instructions for providing privilege logs, for instance. They'll have specific things that they want on there, and that might be different than what you're used to in litigation if you're a practitioner. So you have to review all the instructions and all the information on the CID before responding. Like I said, because failure to do so could take you out of compliance for something as silly as just not providing documents in a correct format. You also want to maintain confidentiality. This goes with CIDs and regulatory cases, but also in litigation. You never want to discuss the facts of your particular issue with anyone besides your attorney, because disclosure to any third parties could potentially result in a waiver of information that could be used against you by the issuing agency. That works in litigation just the same. So we always tell people when we're in a litigation lawsuit, anything you tell us is privileged, but anything you tell a third party is not. And so what happens later on when that third party and things you told that third party and didn't want them to, didn't want anyone to know, all of a sudden become public because that third party is being asked to give testimony. And because it's not privileged, they do have to answer those questions. So keep that in mind. Only discuss any matter related to the CID with your attorney. That's the only privileged communication you're going to be having regarding a CID. And lastly,
can I quickly just jump in really quickly, just to kind of provide an example.
I was almost done anyway. But
I think that's actually a very important one, because we see this a lot in the debt relief space. There are obviously a number of CIDs that are issued all the time, and our job is to tell a client, don't discuss it with anyone, but we can't force our client to not discuss it, right? They go out to these industry events, conferences, right, and they have a few drinks, and then they start telling them that they received a CID. And unfortunately, a lot of times it backfires on them negatively, not because the CID has any negative implication or has any indication of any wrongdoing. It's just an investigative tool. But while it's not uncommon for people to start spreading rumors and spreading frivolous rumors, fake news about, and of course, then I hear this from other clients. Oh, we hear so and so is going out of business, or is being shut down, or is about to get sued by the CFPB or by the state of California. It's just so common to completely misconstrue and misread really the CID, and so. Obviously, both Krystina and I cannot stress enough that if you get a CID, don't discuss it with anyone else, because outside of just the privilege loss that you may incur, because then if you discuss it with anybody other than counsel, you will lose that attorney-client privilege. It also could potentially be creating a lot more unnecessary, heat upon yourself and rumors. Sorry, Krystina.
That's okay, and that's a great point. And really segues into my last point, which is just take the CID seriously. I know we've stressed that a lot on this webinar, but it's so important. You might just receive a CID that's asking for two things, and you go, "Oh, this is simple and easy. I'll just respond to this. I'm not going to take this too seriously." But then you receive 5 more CID requests throughout the investigation, which might happen. One of the recent CIDs that we handled in the firm, I think the one that we were dealing with was the 3rd or 4th CID that this client had received over the course of 2 years. So you're talking numerous requests that started as just one initial request. And so you want to take it seriously. And I think those requests started initially as just requests for documents, and then some information they received, they felt that in connection with that information, they wanted actual testimony. So then it led to their request for investigational hearings. So take it seriously. Don't discuss it with anyone other than your attorney. And even if it's short and sweet, you want to make sure that you understand that it can turn into more than that. And it can always turn into an enforcement action as well, which obviously is not a guarantee, but is a possibility. And that's all I had, Felix.
Thanks, everyone. Thanks, Krystina. We appreciate you listening to this webinar, and thank you for your time. You'll have our contact information on the last slide. Please feel free to reach out with any questions. Thanks again, everyone, for joining.
Thanks, everyone.
And we look forward to seeing you at our future webinars.